Away from that, the Independent National Electoral Commission, INEC, has filed a 6-count charge against suspended Resident Electoral Commissioner for Adamawa State, Hudu Ari, at the State High Court in Yola. This was contained in a statement by the Chairman, Information and Voter Education for INEC, Festus Okoye. The decision was reached at the Commission's weekly meeting to discuss the progress with the prosecution of electoral offenders, among other issues. Recall that the Commission had earlier confirmed the receipt of case files from the police, following the conclusion of investigation into alleged electoral offenses by Mr. Ari. The statement disclosed that the court fixed 12th of July 2023 for commencement of trial. Mr. Ari had announced results for the governorship election in the state in place of the returning officer. My friend Nziako is a legal practitioner, and he joins me live via Zoom from Lagos on this development. For years, we've been talking about what happens after election, particularly disciplinary action taken against people who allegedly fought the Electoral Act. Would you say this is a decision in the right direction, particularly in the area of entrenching democratic developments in Nigeria?
Well, it is a very welcome development. It's a good decision. And because when you look at what the suspended REC did, you look at the actus reus and the mens rea, which we call in law, the intention and the act itself. It seemed the intention was to undermine the democratic process, and the act itself was a bid to torpedo the will of the people. So having been found wanting in both regards and in both respects, the next thing is to let the long arm of the law deal with his issue. Good thing is that he will have his day in court and then be able to tell Nigerians what led him to the act that he did. And of course, this is not the first time we are seeing high-ranking people being taken to court. You recall that an electoral umpire in Akwa Ibom State, under the leadership of the then Rek Makigini, was prosecuted, and he was found guilty by the court and in prison. As we speak, his matter is still pending in the Court of Appeal, but of course the Court of First Instance found him guilty. So what it now means is that is a signal to all Nigerians that our democracy has come to stay and must be nurtured by all people, all the critical stakeholders, and all who have been given the responsibility to nurture our democracy, especially the electoral process through which, that is the only legitimate process through which leadership of the country at all levels are determined. So it's a very serious business for the life of the country, for the welfare of the people, and for development of Nigeria as a nation. And of course, it is an international phenomenon which has come to stay in Nigeria. So I think it's a good development that Yunusa Ari should be taken to court to answer for his misdeeds.
You know, over the years, we have fine-tuned the limit of tribunal cases. Should we also extend such upgrade to cases of this nature? You know, you made a reference to an initial case that is still currently in court. Are you concerned about how long cases of this nature take?
Well, the initial case had been discharged at the Court of First Instance at the Federal High Court sitting in New York, and the accused was found guilty and given some terms of imprisonment. But of course, you know that in our judicial system, there is an opportunity for appeal. He has exploited that opportunity, and his case is in the Court of Appeal now. So this is a criminal trial because he has breached the fundamental laws of election. And in criminal trials, it is expected that it will be given some attention timeously so that the matter will be discharged within a specified period of time. But that is not the same thing as an election petition, which is time-bound. We cannot treat both in the same with the same template. In criminal trials, you don't rush to judgment because all issues must be explored, and then the accused will be given every opportunity to defend himself such that there will not be a travesty of justice. Because justice must not only be done, but must be manifestly be seen to have been done. Done to the society, done to the accused, and done to humanity generally.
Well, in time, perhaps we'll get back to find out if justice has been seen to be done in this particular case. Fred Nziako, legal practitioner, good to see you.
Many thanks.